very glad to be here today. I'm a lawyer from Taiwan, and I'm also a human rights observer of Association of World Citizens. Today, I would like to share with you the principle of an effective state relief application and share our observation of some international cases, and discuss the issue of the rule of law and human rights and the conscience of the state law enforcer. Modern law and international covenants are designed to protect human rights and maintain order in order to preserve the well-being and security of people. Just as the fundamental human rights expressed in the international covenants on human rights derive from the dignity of every human being. The only way to achieve an ideal life free from the fear and deprivation is to ensure that everyone enjoy the fundamental right. Article 22 of the International Declaration of Human Rights and Article 2 of ICCPR describe the key role of the state in the realization of rights, not only in terms of legislative measure to fulfill the effective remedy, but also in terms of obligation of the state to provide effective remedy when people's fundamental rights are violated. The state has the obligation to provide effective remedy for the violation. And the judicial remedy are the first priority in the remedial process. In terms of effective judicial remedy, let me first share with you two famous cases. One is a long-standing case of Hua Chen serial murder in Korea. In 1986, the defendant Lee Cheng-ru was sentenced to life imprisonment after the police falsified the report, and he was tortured by the police to plead guilty. The judge acquitted the defendant in December 2020. At that time, the judge apologized to the defendant on behalf of the judicial system, and the police who made the mistake also reflected and apologized. The other is the famous Japanese case, Ashitaka incident in 1990, in which the defendant, who was wrongfully sentenced to death, was acquitted in 2010 after DNA was re-exempted. The judge and the prosecutor also apologized. These two cases represent a self-reflection and apology from the judicial system for its mistake, and the building of the courage of conscience. However, we observe there is another case that people's rights being suppressed for a long time, and the government obligation to provide effective relief was not fulfilled. It is a landmark human rights violation case in Taiwan, the Taijimen case. In 1996, Taijimen was subjected to political persecution in the name of religious sweeping. In 2007, the criminal court ruled that the case was not guilty and owed no tax, and the case was granted the state compensation. But the tax bureau ignored the court ruling and continued to issue the tax bill. In the end, the sacred land of Taijimen was auctioned and nationalized. The case was attracted the attention and criticism of hundreds of international human rights experts and scholars. And the case has been discussed at hundreds of international forums and conferences. At the same time, 25 international experts signed a letter to President of Taiwan expressing their concern and calling on the Taiwanese government to resolve the Taijimen case as soon as possible, and to implement the transitional justice, and to protect the freedom of religion. But it's a pity that to date, there has been no positive response. This case has been lasting for 26 years, and the extension delays by state authorities violate the right to effective remedy guaranteed by ICCPR. But the people should not have to suffer the disadvantage caused by the defect of the state institution. It is a principle that states need to follow, and it is a principle is supported by the European Court of Human Rights decision in Gressel and Germany case. In this case, the court ruled that the German government has violated the European Convention on Human Rights and ordered the German government to compensate the citizen. The reason is that the entire domestic litigation process took almost 29 years. The court emphasized that even if the litigation was complex, it will not be possible to justify such lengthy proceeding, and therefore the court held it that the right to a speedy trial was breached, and the case should be compensated. There are numbers of cases ruled by the European Court and the UN Human Rights Committee uphold the same principle. The state obligation to provide effective remedy is not only the need for national courts to provide effective remedy, but also General Comments number 31 of the ICCPR states that all government authorities should be committed to the state obligation, and that the state must take every possible measure like legislative, judicial, administrative, education, and all other positive measures to fulfill its legal obligation. In the end, I want to share that it's very important for people to be aware of the human rights, but it is also the responsibility of every government and public official to have courage of conscience and human rights awareness. Whether the human right can be protected depends on whether the authorities are willing to reflect and rectify their mistake, and whether they will willing to face their conscience and take positive action. The point of origin is people's rights and human dignity, and it is important to face the conscience and defend human rights. We hope that all the state agency and law enforcers will be willing to listen to the voice of truth and conscience, and to protect human rights in accordance with the international human rights standard, so that there will be no more unjust case. Thank you very much.